Good day, and welcome to another edition of Q&A Social Security Disability Today. I am your host, Attorney Anthony Reeves, so let's get to your questions. Our first question is, should someone seek legal advice if their condition is only short-term? For those of you who are trying to determine how much time you need in order to qualify for Social Security, the regulations requires that you have an impairment that lasts 12 months or can reasonably last 12 months and keeps you from performing substantial gainful activity. In other words, keeps you from working 12 months or longer. If you have a condition that you believe is probably only going to keep you out of work for less than that period of time, I would encourage you to contact an attorney to determine what your options are. Our second question is, if one has already been deemed disabled, how do you contact Social Security to add another condition that disables you as well? If you are currently receiving disability benefits, there's really nothing to add. In other words, let's say you were found disabled as a result of your psychiatric impairments, whether it be depression, anxiety, whatever the case may be. Then all of a sudden you get in a major car accident. Well, you're already on disability for your psychiatric condition. There's really no need to contact Social Security to tell them that you now have a new condition that disables you. Why? Well, you're not going to get any additional benefits because of that. However, let me throw this one little caveat. If you are coming up for a disability review, and this happens, what I just referred to, then you may want to let them know. Because typically under a disability review, you're being reviewed because they think your current condition has improved. However, if you have a new condition that renders you disabled, you want to make sure you let Social Security know at that time. The most important thing that you can do is that if you have a new condition that you believe disables you, continue, I stress, continue getting the medical treatment that you need. Our third question relates to the Clark v. Astro class action lawsuit that originated out of New York. A relief order was issued on April 13th, and one of our questions had to do with what's the status of that relief order. For those of you who may not be aware, Clark v. Astro is a class action lawsuit that originated out of the 2nd District, United States Court of Appeals 2nd District, which is out of New York. There was currently a relief order according to the question on April 13th. However, that order has not been made available online as of yet. Once I get that order, please send me a message back and I'll be more than happy to review it. Our last question, our fourth question is, I was denied 4 times and I was told that if I am denied 3 times, that on the 4th time they have to approve me. Is this true? Social Security is not an entity that's going to award you benefits just on the number of times you apply. Meaning you can't wear Social Security down and say, okay, well, you applied 10 times, we'll give it to you your 11th time. If you qualify, they will award you benefits. It's not based on the number of times you apply. I stress that to people all the time by telling them, if you are eligible to apply, you are entitled to apply. The number of times you apply, appeal, or denied does not entitle you to benefits. At all times, you still have to qualify. Again, I want to thank you for joining me for another edition of Q&A Social Security Disability Today. As you're aware, we do have a chat function on our blog at legalbeat.anthonyreeves.com, so feel free to chat with me live when you see me there. There's also a phone line that gives you the ability to leave messages regarding disability topics that you'd like me to address. So please take advantage of that as well. As always, keep those questions and those comments coming. And if you have any further questions, if I can answer them, I definitely will. My name is Attorney Anthony Reeves, and this is your Q&A